Good morning, everyone.
Morning.
We have, I believe, 8 members here in Albany, if I'm not mistaken, and we have 2 people, Judge Mazzarelli and Marvin Schechter, joining us from New York City. The first item on our agenda is a review and approval of our meeting agenda. I believe the agenda was sent out to everybody in advance. Any comments or questions? And if not, do we have a motion to accept the agenda?
So moved.
Do we have a second?
Second.
All in favor?
Aye.
Anyone opposed? I believe we also had the minutes from our December 9th, 2016 meeting distributed to all of the commission members. Are there any questions or comments with regard to the meeting minutes from that meeting? And if not, do I have a motion to approve those minutes?
Motion.
Motion. Do I have a second?
Second.
All right. All in favor?
Aye.
Anyone opposed? I believe we also had included in the materials that went out the minutes from our February 10th, 2017 meeting. If I'm not mistaken, there was a joint meeting of the DNA subcommittee and the commission. Any questions or comments with regard to those minutes? And if not, do I have a motion to approve those minutes? So moved. All right, do I have a second?
Second.
All in favor?
Aye.
Anyone opposed? The next issue, I know my agenda reflects this. I'm not sure if everyone's does, but I do want to make sure that we have the time that we need for the familial search issue. So the next item on the agenda that I propose we address is under old business. The first item there, and that's the familial search issue. There were 3 documents that were approved by the DNA subcommittee. It was not a binding recommendation, and that was intentional because we wanted to give the commission the opportunity to review all of them and weigh in, as opposed to just being put in a position of a yes, we accept it, or no, we send it back. Those 3 documents were a policy with regard to familial searching, an amendment of our regulations to reflect the familial search policy, and a DNA implementation plan, again, amended to reflect the changes in the familial search policy. What I would propose, and I guess a comment with regard to the plan. The implementation plan for a period of time was not kept by DCJS. I think if you read the plan, you'll see that it was not updated to reflect everything that the commission and the DNA subcommittee have done over the years with regard to DNA. So the changes that are reflected in the implementation plan that you have before you reflect the changes that the DNA subcommittee recommends with regard to familial searching. I believe there's still some work to be done in terms of updating the remainder of the plan to reflect issues that we've addressed other than familial searching. So, it's our plan going forward to completely update the implementation plan apart from familial searching and make sure that it's up to date and reflects everything that we've done as a commission. We did not do that in the context of this issue. I didn't want to confuse the two. I thought it would be better to separate them. So with regard to the plan, if we can just focus on the familial search aspects of it today, and we will have the plan fully updated and brought back to the subcommittee and the commission for review at another time. What I would suggest is, yes, Marvin. Yes.
I just want to be sure that I understand the process that you just alluded to in your remarks. The statute requires that the DNA subcommittee consider an issue and make a binding recommendation to the Commission on Forensic Science. The Commission, by law, then can either accept or reject the recommendation. If it rejects it, it sends it back to the DNA subcommittee. That's the law as I read it. All the
And it-
materials that we have in front of us for consideration today, all the materials that we have in front of us today for consideration, what are they classified as? Is this a report from the DNA subcommittee? Is it informational material for us? And then all the remarks and suggestions and comments and suggested changes would then be reported back to the DNA subcommittee, which would then make a binding recommendation at a later date? Is that the process as I understand it?
Yes, this, what I would classify this as is either guidance or recommendations from the DNA subcommittee to the Commission on Forensic Science. As I indicated, I wanted to give you and all the other commission members the opportunity not just to be put in a yes/no position, but the opportunity to weigh in. Assuming that we come to some agreement or that as a commission we're able to approve something today, it's my view that it would have to go back to the DNA subcommittee for them to then consider it. And if they choose, issue a binding recommendation, which would then come back to this commission for us to either accept or send back to them.
Thank you.
No, thank you. So what I would suggest we do, just in terms of trying to put some order to the consideration of these issues, is start with the policy. I think first address any overarching issues, then go through the policy section by section, address any issues people want to address. And hopefully through that process, we will address all of the substantive issues. As I read the regs in the implementation plan in terms of substance, they just repeat or duplicate what's in the policy. So then, once we finish the policy, hopefully we'll have addressed all of the substantive issues. We can then go through the regs in the implementation plan if there's any process issues people want to raise. Assuming that's acceptable with anyone, we'll start with the familial search policy. It's on page 47 of the materials that were sent out. And again, what I would suggest is if we start with any large or overarching issues people want to raise with regard to the policy itself or the issue of familial searching, and then after we've dealt with those, go through the policy section by section and deal with any issues people want to raise pertaining to particular sections of the policy. So I will open the floor up at this point for comments, discussion, questions. All right? Yes.
As an overall, starting with the big picture, there are a lot of details not here, understandably, but that makes the policy seem, in my opinion, overly broad. I didn't attend the most recent DNA subcommittee, we don't have minutes from that meeting, so I don't know whether those details, some of them may have been clarified, but looking at, just in terms of how many times is this event, which in my opinion and understanding is supposed to be a rare event. Otherwise, we will be spending extraordinary investigatory resources and potentially invoking privacy of an extraordinarily large number of families. So it would have been helpful in the background of the proposed policy. So how many arrests are out, how many investigations are out there involving these categories of crimes? Are we talking 10? Are we talking 10,000? That's your first level of decision as to whether familial searching is going to be considered an option, right? It seems like a very broad list, right? We get down to these, anything involving a threat. It's not. Originally, we talked about, and most states have talked about, a very restricted list of the kinds of crimes.
Dan, are you talking about case requirements?
Yes. Okay. 1 through 4 gets you an awful lot of different crime investigations, doesn't it? I mean, I have no idea. I didn't go to the code. I didn't make a list of all the,
Well, they're the most serious felonies. There's homicides and sex offenses.
not if you include number 4.
Well,
When you say number 4, what are you referring to and what page?
It says crimes presenting a significant public safety risk, threat.
Okay.
That
thank you.
makes it potentially, I mean, I'm raising curiosity. Are we talking about 100 a year? Are we talking about 10,000 potential cases? And someone should be able to get that data.
I mean, I guess I look at this differently, and I don't believe anyone can get you the data. I can get you the data. I can tell you, for 1 through 3, for example, in any given year, how many arrests are made. We have that information at DCGS based on the fingerprints that come in. But there are so many other things in this policy that limit it. That,
Right.
First of all, do you have a sample of something left at the crime scene, which has a close enough connection to the suspect, from which a DNA sample was able to be obtained? Is it the type of profile that would qualify here? Was there no match found through the DNA database on a direct search? Does it meet the other criteria? So I guess as I look at it, and we both have different points of view. I think we've been in different parts of the system, so we look at things differently. But as I read this policy and look at it from my perspective, I don't see any way that you could say it's going to be 10 or it's going to be 20 or it's going to be 50 with any degree of certainty. But I guess I tend to read this differently in that I look at this list of charges and I look at it in relation to what other states have done, and I look at it in relation to what people asked us to do at the public hearing, and I think this is pretty restrictive compared to some of those comparisons.
Okay. Then, as
And I don't know
a
if this
policy
would-
writer,
I don't know if this would help you, but Oneida County is the 16th largest county in the state. I don't have a case that I would do this on.
Okay.
Okay, so I don't know. I like what Commissioner Green was just saying. I have no idea what's the situation in New York City, but for our county, there's not one case where if this was to be implemented that I would make a motion or that I would ask to search. No.
that is helpful.
Okay.
Not because I want to limit the use if it's important to have. As a policy writer, I would have inverted the policy. I would have started with the most likely limiting criteria. There has to be a profile. It has to be a single profile. I think adding a deduced profile potentially opens it to implied data rather than actual data, but that's a detail, not a. It looked very broad to me because I'm not familiar with the kind of data you have.
I looked at it the other way.
That was an example of a potentially very broad, with a lot of details missing. It says the investigating police agency and the DA, and it's an and, have to make the request in a form to be determined, because we don't have that form yet.
See, I look at it as much more restrictive because I see the word must. So
Well,
that
but
means
that's-
the police can't do it without me.
Yeah, but that's not what it says.
That's not what it
It
says.
does, investigating and must certify.
Well, I was just trying to emphasize, do we really mean and?
Yeah,
And must.
Yeah, I mean, I'm just,
I'd say
I'm raising the questions. I am
The
a
intent-
proponent of limiting the use of family searches. Let's put that
To
on the
answer your
table.
question, the intent, and I think it's consistent with the wording, is that both the police agency doing the investigation and the prosecutor have to jointly make the application. They have to both agree it's appropriate, because, at the end of the day, we shouldn't, in my view, be engaged in the search and the process and everything that's involved in it unless the investigative agency feels that it's absolutely needed for the investigation, and the prosecutor is going to have ultimate responsibility for pursuing this case, agrees that it's something, that they would move forward on. So, yes, it was done that way on purpose. I think the wording as written requires both of them to jointly make the application, and that was the intent. And it was done so, again, as a limiting purpose to make sure we're not doing this in cases where the DA says, gee, that's great, you did it, but I have no intention, following through on this anyhow.
Do we?
Yes, Marvin.
I don't want to cut Ann off, but I'd like to be heard on some of these points that Ann's addressing. If she's finished, I'll wait.
No, we'll make time for everyone to be heard. So, if it's all right with you, Ann,
Can I ask?
Sure,
put one more item on the table for your consideration, Marvin.
You will be next, Marvin.
Thank you.
The other aspect of this, and it's similar, it's statistics that we might have that would help us predict the kind of effort that this is going to invoke. It would be possible in the existing DNA database, right, to select a random case. It doesn't have to be a cold case, just a random case, a few random cases, and ask how, if you were to search a pure sample obtained in the investigation of a case, whether or not you solved it, whether or not it went, against the existing state database, which is the database we're going to search for our family members, how often would you identify a potential family, and how many families? You're only looking for half of the markers to match to find a first-degree relative. All right? That's the first-degree relative search. The number is potentially very high. I'm trying to get my hands around.
You're talking hypothetically, we find.
Hypothetically.
We've got a profile, nobody's in CODIS with that profile, we run it through the familial searching algorithm.
Oh, yeah. How many families are you going to find?
I would suggest that based on the testimony we heard from Colorado and California, not many.
No. They said not many worth investigating because they started at a different point. They didn't start with the database and a random search. They started with cases that hadn't been closed. That's a very different question.
But isn't that, and I guess I'm not quite following, but when we do this in reality, aren't we going to be doing it on the scenarios that the folks in Colorado and California described to us, as opposed to just on a random case that we pull out?
I hope so. Okay.
Isn't that what the policy calls for?
I hope so. But I think you potentially...
Beyond hope, isn't that what the words on the paper say?
I'm looking at it from a different, as you've agreed. We look at it I'm looking at this strictly from a genetic probability statistic. Understand that my first husband and I are sibling match, are not just sibling matches, we're identical twin matches in this database. We are not related. All right? So statistically, genetic...
You married your brother? What the hell?
That's what I was accused of for decades. My twin brother. Anyways.
I didn't know you were from Kentucky.
I have to admit that I spent a lot of time preparing for this. I never envisioned
No wonder you got divorced.
He died. Anyway. And it created medical risk for my children, unfortunately. But we are not related. So it's a personal experience that says genetic data has pitfalls. All right? And I'm just raising that potential issue that this policy may not completely prevent because of the data itself.
But it's only an investigative lead. It's not.
Well, I understand that, but it potentially impacts a lot of families, even if you start with the cases that need to be. You've asked me what my broad opinions are. I've shared them, and I'll be quiet now.
Sharing them, and I guess what I'm weighing in my mind is how does that fit with what we heard from people in states who have been doing this?
you can analyze their data differently. But I'm not.
No, I appreciate it.
I think before we even,
Marvin, on. Marvin?
Sure. So it should come as no surprise to you, Michael, and to DA McNamara, that the both of you take a look at the policy and you see a broad restrictive policy. I looked at the familial search policy that we're discussing, and what I saw is a proposal to replace direct DNA matching, partial match DNA matching, with familial search. I didn't see this policy as restrictive at all. And let me point to 3 areas that tell you right off the bat that this is not a restrictive policy. First, in page 47, part 1, case requirements, A4, after listing all of the crimes that the DNA profile must be associated with, we come up with this. 4, crime presenting a significant public safety threat. There's no further definition anywhere in the policy, none in the history memorandums that I've read, none in the list of definitions of what that means. So who determines what that means? Crime presenting a significant public safety threat. The answer is the prosecutors. They're given that responsibility, and they determine whatever that means. So to partially answer Ann's question, we don't even have to discuss the statistics of what may happen as a result of implementing this policy. We can see that using item number 4, 1A sub 4, a prosecutor could take a familial sample, what they deem a familial sample from a crime scene, in a situation that they deem a significant public safety threat, whatever that means, and initiate a familial search. If it was really true that we wanted to limit familial search, item 1A sub 4 would not even be in there. In fact, I don't know of any state that has similar language. It's possible, and if there is similar language in other states, we ought to find out from those other states what that language has meant, what those states did with that language, how many cases did DAs and law enforcement come to the state DNA database of that state and request a familial search based upon presentation of a significant public safety threat. Point number 2. On page 47, case requirements 1, sub B. Quote, the investigating police agency and appropriate district attorney must certify. So let me just stop right there. What you're asking us to believe, Michael, with your comment, that the must in the enabling language of Part B, that the appropriate district attorney and the investigating police agency must together certify, strikes me as being unbelievable that in any high-profile case, or in any case of significant high publicity value, that the police, law enforcement, working hand in glove with the district attorney, would not certify the use of familial searching. I haven't seen examples of that. In fact, I'd say most of the examples I've seen in a 43-year career is that the police and the district attorney pretty much agree on everything. There are times where district attorneys and police will disagree about certain questions. Some have been raised in this commission by the 2 district attorneys sitting up in Albany. But the fact of the matter is, in a high-profile case, this is what's going to happen. And indeed, the case that brings us to this discussion here today, the unfortunate death of Miss Vertrano, is a classic example of what occurs when we have a high-profile case where the district attorney sent this commission a letter in December, Michael, I think of 2016, I could be wrong, indicating that all leads had been exhausted, the police had done everything they could, and the two agencies wanted this commission to enact familial searching policy. Which brings me, of course, to B sub I. Reasonable investigative efforts have been taken in this case. I don't know of any other state that has that language. I don't know what that language means. Reasonable investigative efforts have been taken. But I read that as a green light for any district attorney to tell this commission that we've investigated. We don't have to tell you what we've done, because that's not required here. We don't have to tell you how long we've been doing it, or where we've been doing it, or when we've been doing it. But we've made reasonable investigative efforts in this case. And that goes undefined in the history memorandum. It goes undefined in the definitions, what that exactly means. Previously, standard had been all exhaustive efforts have been completed. All efforts have been exhausted to determine what is going on with the case. We've come to a dead end. And just to underscore this point, so that there's no claim later that I warped this discussion, this case, the Vertrano case, which brought us to this discussion, started with a letter from the Queens District Attorney's Office telling us that all exhaustive leads had been completed. There was nothing further we could do. And based upon law enforcement and the district attorney, we want the commission to enact a policy on familial searching. And lo and behold, less than 3 months later, what did we find out? That all exhaustive leads had not been completed. We were not told that the truth as to the exhaustive leads, at least in that case, because what turned out was there was a police officer in Queens, I think it was a lieutenant, who suddenly figured out that he had given out a desk appearance ticket to some guy out in the area. They went back and looked at desk appearance tickets, and lo and behold, it led them, not with the use of DNA, but through old-fashioned police efforts, to find the alleged perpetrator of that malicious and horrible crime. Third, on page 47, case requirements, sub B, I. Exigent circumstances exist warranting a familial search. So that's an or with respect to B sub I. So it's one of the two. If you're a prosecutor, you have two shots at going to the Commission on Forensic Science and saying it's one or the other. Whether we should even have such a choice seems to me really not restrictive, but designed to enhance as much as possible the possibility of the commission granting familial search as the initial step in an investigation. Exigent circumstances exist warranting a familial search is undefined. We don't know what those exigent circumstances are. We don't know if it's a serial killer. We don't know if it's a one-off. We don't know what required exigent circumstances to be included as the alternative. So just on those three sections, case requirements 1, sub A, sub 4, and B, sub 1 and 2, I read the policy as failing miserably to address what Ann is talking about. And you don't have to worry about the statistics of how many cases may be found. What we're going to see is an exponential increase in the number of familial searches that will take place in this state. And let me just finally underscore the last point just with respect to these subsections. And it's the elephant in the room, which unfortunately very few people addressed at the commission meeting held open to the public, with the exception of one eloquent fellow from the Bronx, from Bronx Defender Services. As written, the full impact of familial searching will be felt largely on communities of color, because it is the communities of color who by want or dint of how we operate our system, our culture. No sense complaining about it here. It's beyond the commission's control. But that's the group of people who are going to be impacted by these three sections, which allow the police and the district attorney's office to investigate wholesale groups of people in a particular group or subclass of the population. That's not fair, and it's improper. And if you're going to have familial searches, and you know in advance that your state DNA database has an exceptionally large population of people of color, then what you would want to do is to limit familial searching. Instead, here, it gives rise to increased familial searching. There was a remark made, I think, by District Attorney McNamara that these cases, after all, they're only investigative leads. They're only investigative leads where the police come to your apartment, knock on the door, and they want to know information about other people. An incredibly unsettling and embarrassing moment for any family, white, black, or otherwise. But to be sure, we should not minimize the fact that investigative leads means nothing. It means a great deal to the families who will be subjected to what amounts to a genetic stop and frisk. And in this case, the stop and frisk doesn't even meet the stop and frisk standards of Terry versus Ohio. We don't even have a reasonable suspicion. All we have is a piece of DNA at a crime scene. We don't even know if this piece of DNA has anything to do with anything. And if Mr. Gestring is right, when we asked him about past partial DNA matches, we found out that in the 3 cases out of, I think, 45, that in 2 of those cases, the partial match DNA turned out to be a match, but it turned out in one case, I think it was a cigarette butt. It belonged to the son or the cousin of the woman in the apartment, and he lived in the same apartment complex. So for all of those reasons, just dealing for the moment with these 3 substantive points, I would say to my fellow commissioners, demand to have these 3 sections either removed or better defined. Because if we don't do that, we are giving a green light to the prosecutors of this state, a state which, by the way, right now is either first or second in the nation in wrongful convictions, to go all out and use a new weapon, familial search, which may be helpful. I haven't even concluded yet whether or not familial searching may be a tool that's valuable to us. It certainly would be valuable to me as a parent if my child were the victim of a crime. But it does seem to me that this needs to be narrowed down. As written, it's unacceptable. Thank you.
Thank you for the comments. Let me make a few comments, and I'll open it up if anyone else wants to. But first of all, with regard to the argument that you make about the effect on communities of color, I can't help but think about Mitch Morrissey's remarks at our joint hearing. However much we may speculate about the composition of the DNA database and what effect that has, I think he, at least to me, fairly articulately made the point that a large number of the crimes that have been solved and will be solved using familial searching are crimes where people of color are victims. They're the ones who are impacted, and in many instances, they will see justice as a result of that. And I'm not going to repeat everything he said, but I thought, at least to me, that was very persuasive. Secondly, you raised the wrongful conviction issue. And as I struggled and thought about the idea of familial searching, I kept going back to the case in North Carolina where the person spent 18 years in prison for a crime they didn't commit. And it was only because a familial search was done, which led to the identification ultimately of the person who actually committed the crime, led to the exoneration of that person who spent 18 years in prison in North Carolina, and led to the true perpetrator of that crime, and I think it was a rape if I remember correctly, being convicted. And I thought, if in fact wrongful conviction is an issue which we should be concerned about, and I certainly think it is, how do we not adopt a familial search policy knowing full well that that familial search policy has the potential to exonerate someone who's been wrongfully convicted and is currently sitting in a prison cell in New York? How do we sit here, put our head in the sand and say, no, we're not going to use this tool, which may help us right an injustice which has been done? And secondly, going forward, if familial search provides investigative leads that help point police and prosecutors in the right direction instead of in the wrong direction, and help prevent wrongful arrests and ultimately wrongful convictions, again, how do we say that we don't want to use this tool if we're concerned about wrongful convictions? So I share your concern about wrongful convictions, but frankly, for me, that is a reason why we should be adopting a familial search policy. As to the specific issues you raised, I can just comment on the intent in terms of putting some of that language in there. And with regard to the crime presenting significant public safety threat, we were trying to keep this as restrictive as possible, yet still not foreclose it in cases, and people gave different examples. And I think the example that came up is you have someone who's slashing women's faces, and they're doing, every 3 or 4 days, another woman gets her face slashed. And, on the third or fourth one, maybe the knife is dropped and there's DNA on the knife and it doesn't come back to anything and the slashings continue. Now that doesn't fit any of the articulated crimes in our policy. But you look at that case and say, if we did a familial search and that gave us an investigative lead that would solve that case and keep a woman from getting her face slashed every 3 or 4 days for the next 5 years, to me, how do you balance? One way we could account for that is we could expand the crimes. And we could say, let's include all felony assaults and let's include robberies. And someone else says, well, what about the burglary? Where someone's doing burglaries every 4 days and, God knows doing what to the occupants of the house. And so one way to deal with those situations is just make the crime list so expansive that you cover all those scenarios, but then you also bring in large numbers of cases where it may not be appropriate. The other way to cover it was to try and put language in that in those exceptional cases, like the face slashing example, would allow you to do it without making the category of crimes overly expansive. As to the comment about the district attorneys or the prosecutors making the decisions, that's not the way the policy is written. The way the policy is written, ultimately, it would be the prosecutor and the police chief that need to supply information setting forth their claim as to why they believe this is a crime presenting a significant public safety threat. But ultimately, it's the commissioner of DCJS that has to make the determination as to whether or not they've articulated sufficient facts to meet that threshold and justify going forward. And the same thing with reasonable investigative efforts. I think you highlighted the problem, to me at least, with the exhaustive language. Now, I don't know that you can ever say you've exhausted leads. No matter what you've done, you can always, at least in my experience, you can always think of something else, and then you can always think of something else. And, the chances of, as you go forward, the chances of those things leading to anything are slim. So I thought the exhaustive language is basically setting people up to fail, because I don't know how you can ever say you've exhausted every lead. On the other hand, to address the concerns people have raised about this not being done too often, we didn't want people, police or prosecutors, coming in here before they had done anything on the case. And as their first step in the case, after a profile was run through the database and didn't get a hit, saying, let's do familial searching now. So this language was an attempt to balance those two. And without using the exhaustive language, which I think is, not workable, I think it's kind of a fictitious concept, it was an attempt to require that efforts have been taken. And again, at the end of the day, you say no facts, they don't have to tell us anything. But the way this policy is written, the commissioner of DCJS has to make a determination that what they've put in the application establishes those things. And I can tell you, if you just write a conclusory statement in there that reasonable investigative efforts have been taken, as I read this policy, I don't see that gets you to the point where the commissioner could possibly make that determination. As I read this, they're going to have to spell out, what they've done to establish that threshold. And you also highlighted the exigent circumstances argument, and again, that was an attempt to balance. How do you account for that rare case? And the case that comes to my mind is the sniper case around the Washington, D.C. area. And you've got someone doing shootings. Do you tell the police, when you're having a shooting every 2 or 3 days, and you've got DNA that you ran through the database and didn't hit anything, and they want to do a familial search, no, we're not going to do a familial search until you spend another month investigating, even though we know that, 10 more people will probably be killed in that next month. And how do you balance those two so that it's not the first thing you do in every investigation, that there's a general requirement that they go farther, but in that rare case, like the DC sniper case, you have the ability to look at it, and if they make sufficient allegations in the application, say, yes, this is an exception. So, I understand your arguments. I appreciate them. This language was an attempt to balance different things, and I think, we will disagree on whether or not we've struck that balance or not.
I had a question.
Well, can we,
Go ahead, I'll refer to the judge.
Go ahead, John. You're next, Bill.
Some of the privacy concerns that exist with respect to search warrants and wiretaps are similar to some of the privacy concerns that exist here. So I'm just curious as to why the determination was made not to make the application to a justice of the Supreme Court or the appellate division as search warrants and wiretap applications are made, and instead to make it, with all due respect to the commissioner of...
You won't offend me by this argument.
So I'm just curious. To me, it would provide a little more distance from the DAs and the investigatory agencies to the granting of the application. And it had been my impression that an application for this kind of search would sort of look like an application for a wiretap or a search warrant, which would include everything that's been done, why, there's a reasonable probability, a reasonable standard that we require there. And I just was curious as to why that decision was made.
And I think one factor that weighed heavily on that point was I don't know that we have the authority to create, clearly in the criminal procedure law, they can dictate what judges do and what judges don't. I don't know that the commission, given our statute and our grant of authority, has the ability to set forth a procedure that requires judges to do things like that. The examples that you mentioned are things where the criminal procedure law specifically assigns certain things to judges.
I know that other states do that. They require the application to be made to a judge.
Yeah, I guess I'll have to double check. I'm not sure that any other state does that. I know a couple of commission members are indicating that they don't believe that any other state does.
I can check for you now.
The bill that's currently in the legislature would require court.
Yeah, and certainly the legislature, nothing we do here precludes the legislature from acting, and if they think it should go there,
I understand.
yeah, I clearly don't argue that they have the ability to do that. We looked at that. Frankly, personally, for me, would it be easier if I didn't have to make these decisions and someone else did? Sure it would. But I just, at the end of the day, no one else did it as far as I recall, and I thought there were serious concerns about whether or not we had the authority to do that. Bill, you?
Yeah, thanks you, Mr. Chairman. Judge, Barry Scheck and I, 5 years ago, we actually drafted a statute that would cover the grounds that you covered, and it went absolutely nowhere in the legislature. They ignored it, and no explanation why. To get Barry and I on the same page is something that we agreed on. You would think it would have been something that would have been attractive to them. Apparently not. But anyway, let me address some of the very thoughtful comments by Ann and Marvin. First and foremost, I think we're focusing on number one, which is great, but I think we're forgetting number four. The additional requirement of YSTR analysis and some type of likelihood ratio threshold that has to be met before you even continue to give some degree of likelihood that you actually do have a legitimate blood relative of the perpetrator. I think that's extremely important. When I first looked at case requirements, and I'm not speaking for Scott, he may have had the same impression, I thought it was unduly restricted. What about home burglaries? What about violent robberies? What about assaults? What about a vehicular assault? If someone cuts themselves fleeing the scene of someone who's had their legs cut off. But I understand that. I understand why the restrictions were made. This is the first step. This is not a perfect familial search policy, but something that's very, very probative and good should not be the enemy of the perfect. It will get better with time. A lot of the things, Ann, that I think you're anticipating may or may not happen. If they do happen, I'll be the first one. If we're getting thousands of requests for familial searches, then obviously this commission is going to have to revisit this policy. And just parenthetically, I know Scott said none in Oneida County. Onondaga is the 10th largest county. I just checked with Kathy Corralo. She said maybe 4 cases. Now, that I think could give you some translation into what would occur statewide. And in terms of Marvin's criticisms that the police and prosecutors will always agree. Marvin, I'm going to send you a subscription to my hometown newspaper. Read about my very, very close personal relationship with the hierarchy of the Syracuse Police Department. But I don't think it's the prosecutor that determines under number 4 a crime presenting a significant public safety threat. I think the prosecutor and the police merely have to assert that in their opinion that is the case, and then it has to be reach the imprimatur of the chairman here. And in terms of high publicity value being the writing factor, I can tell you, short of a serial killer, the most publicity, and Scott will back me on this 100%, that you get on a criminal case as a prosecutor is if somebody leaves their dog Fluffy out overnight on a cold day in Syracuse. I will get a minimum of 100 emails and letters. I do not plan, if I find a blood sample on the chain that Fluffy was attached to her collar, of asserting to the chairman of this commission that a significant public safety threshold has been met, and I really need to catch this guy that's leaving dogs out in the cold. It is unfortunate, and Marvin actually brings a good point. It is unfortunate that it takes the Vetrano case to bring us to this point. I was talking about this, Mike Green was talking about it, I know Scott was talking about it years ago. This is good sound science. And this policy is just really, really well thought out, well defined. And we're going to see where we go with it depending on what this commission goes through today. But just real quickly on a couple of other things. And Mr. Chairman, you touched on this, exhausting all leads. I have a cold case squad. And we don't talk about cases unless we think we've exhausted all leads. Well, we solved some of those cases. We have never used familial searching to solve those cases. Does that mean that we lied when we said we exhausted all leads? Of course not. Does that mean that Judge Brown misled this commission? Absolutely not. The case was at a dead end. A very, very intrepid police officer was going through reports, checked this individual out, who, by the way, is presumed innocent at this point, and re-interviewed him, he voluntarily gave a sample. If he had asserted his right to counsel or refused to give a DNA sample, then we'd still be in a situation where this crime would be unsolved. And I think, interestingly enough, the partial match policy that we have in place now, correct me if I'm wrong, Mike, but the 3 cases that have led to some type of resolution, none of them would be eligible under the familial search policy. So you actually have a more restrictive policy that we're looking to put in place here. And with that said, thank you.
People haven't had a chance to weigh in yet.
So, at the special meeting, the NYPD made a lot of points about why they felt that this was a valuable tool. And in their view, they're interested, they say that they should have discretion, and they also wanted to use it for hot/fresh cases, which I don't know how that fits into the reasonable investigative efforts or exigent circumstances, but they have, and as a manager who works in this DNA laboratory, I know that we receive many, many requests. So I would guess, not having had a conversation with anyone specifically about the number of cases that they may have in the hopper waiting to be presented for this policy, I would guess that it would be more than 3 or 4. Then there were a couple of other...
Maybe if I can, just to address those points, and then I'll give you the floor back. This policy is drafted is, in my opinion, way more restrictive than what NYPD asked for.
Absolutely.
NYPD asked for a policy that gave them permission to search databases other than the state database, which this one absolutely does not do. You know, I don't think they wanted any limitation on the types of cases. This one, you know, very few classes of cases under the penal law are covered here. They, you know, argued that there should be no limitation in terms of having to take reasonable investigative efforts.
But can I interrupt back?
Sure.
Because I just wanted to give you kind of like the other end of the spectrum of the type of what we could potentially anticipate for requests. So obviously we have a spectrum of small to large of what we could potentially be seeing down the road. And just as an aside, I was wondering whether we were going to take into consideration potentially ramping up and having an easing in of the policy, whatever it is that we end up beginning to do. But that's just an aside. Another comment that was made by Bob Perry, and which I've always felt as a scientist, is that our advances in technology outpace the law. So when we go and testify, and when we're prepping the prosecutors and we're talking about, you know, well, now we're dealing with likelihood ratios, and they're just comfortable with RMP, and they're really upset that they have to now walk away from something that they understand to something they don't understand. So if we're talking about the professionals who interact with us, how do we deal with the public who now when we go in and testify, they get DNA, they understand DNA. But do they understand that we're going to go from it's a match to, well, it's not a match, but it's in your family? And what are we going to do for the public, to help the public understand that we are now moving beyond the initial scope of what it was that DNA was created to do? Yes, I understand that science has advanced. When I started, I was doing DQ alpha and polymarker. I'm old. I've been doing this a long time. But as we advance, I think that we also need to be sure that the public understands what those advances mean. And I include in the public the convicted offenders, because the convicted offenders and their families, when their profile was, when they were told or when they're informed that their DNA profile was going in the data bank, there was no explanation that at some point in the future, your DNA profile that's going to stay there forever can now be used to potentially identify someone in your family, and that the family doesn't understand that now that this is something that has come down the pike and hey, we're getting ready to use it. So I think that communication and being a little bit cautious about how it is that we move forward with this is not a bad thing, because there are people who are going to be, in my opinion, potentially affected. I am a person of color, and I thought, Mike, you did say that you were persuaded by the argument that people of color are victimized, probably more than people who are not of color. But then you've got family members, and I've got great family members who have done wonderful things, and I'm here representing the people of the city of New York and now the people of the state of New York. But then maybe you have that family member who, for whatever reason, is now in the database. So I think that we need to be thinking about the fact that now they are affected in a way. They've been affected emotionally. They may have been affected economically. But now there's a potential that they could also be affected genetically. So I would like us to keep that in mind as we move forward. I think that some of these definitions can be defined, these words can be defined very broadly. So are we going to take into account, how are we going to define reasonable? How are we going to define exigent circumstances? How are we going to define presenting a significant public safety threat? I agree that all of this needs to be taken into account as well, but how we define it and how we put a time frame on it, I don't know whether that's something that we could figure out how to cover in this policy.
I guess we may have started in at least the same era, because I started as a prosecutor using DQA1 and polymarkers as well. So,
okay.
The one thing I would clarify is, you referenced the public and juries understanding familial searching, and at least as I understand how it's been used and how the policy is laid out, I don't see this as something that could be presented to a jury. I see this as an investigative lead, and I think the way at least I'm familiar with the cases I've looked at, how it's been used, at the end of the day, if that investigative lead proves to be useful, the result is a court order to take a sample from the person who ultimately is the suspect, if in fact the law enforcement can develop probable cause to get that court order. And then there's a direct comparison between the crime scene sample and the sample that was obtained from a court order. And if that matches and there's a prosecution, that's what juries hear. I'm not aware of any case where the familial search results were presented as direct evidence. And I've looked at a number of the cases. I can't say I've looked at every single one. So I understand and appreciate your arguments. I just think it's important we keep clear how this has been used, and it's envisioned it will be used, and how it won't be used.
Thanks, Commissioner. Just a couple things to address. First, Marvin's thing. The fact that you try to put forth that police and DA always agree, that's absolutely not true. And although Fitzy's is a lot more public, I think any DA would say to you that we disagree with the police probably more than we would like. So I think the fact that you have it included as an and that we must do it together, I think that is very limiting, because we are stopping the police from doing an end around on us. You understand, you used to be a DA. The police do try to do end arounds on us. And so there are times, and we're elected, and they're not. So what ends up happening a lot of times is we'll say, whoa, wait a second, this case doesn't fit. And I'll get to another point in a second about that. So I think that's very restrictive. I also think in that B, it indicates that it has to, the form and the manner is what's set forth by the Division of Criminal Justice Services. And I would be remiss if I didn't explain to the other commissioners here what it's like to deal with DCJS. Okay? And I don't say that in a bad way. No. But I deal with DCJS all the time. Okay, and unlike a defense attorney who never deals with DCJS, I deal with them all the time. I deal with DCJS when we're dealing with issues, whether it's stuff with the database, fingerprints, criminal records, or more importantly, when we apply for money. Okay, so I understand how restrictive and how I can't just call Mike Green up and say, hey, Mike, I need $100,000 for investigative purposes. Give me the money. It doesn't work like that. It's very complicated. There are always policies. So when I see this, I just see one more step of, this isn't going to be easy because it's not easy. So that part of it, I think is good. And I would be remiss if I didn't share that with you. The DCJS just doesn't give the DAs and the police whatever they want. We have to go jump through a lot of hoops, and you have no idea what the application processes are for some of these grants that we apply for. Or maybe you do, but being a person that applies for them, I appreciate how difficult it is. And when I read that, that's what I saw. The fact that you brought up, Commissioner DeCastro, I agree with you. I'll tell you one thing right now. The thing I struggled on this the most is the privacy issues. I would not kid you on that. I look when I think of any of this stuff, I always look at it from a personal level. And so, if I had been in trouble, and the state had my DNA, and I'm sitting at home one day, and the state police knock on my door, and they say, hey, Scott, we want to know, who are your relatives, and, what's been going on or anything like that. Yes, I would find that an invasion of my privacy. There's no doubt about it, and I agree with Marvin on that part, and that's the part with everything we do, okay? Whether we're executing search warrants at people's houses or tapping their phones, we're always invading people's privacy, but we're balancing it against the needs of society to bring people to justice or to hold them accountable. So I look at that and I struggle with that. But when I looked at the overall limiting of this, these are very, very unique cases. And when I look at this, like I said, I don't see this happening a lot. I'm sure the commissioner probably could get a statistic just to show the type of cases that are included over the total amount of cases. We would get that number, but then you also have to put on top of that you have DNA that doesn't match somebody else. So first of all, you have to have DNA, and we don't have DNA in a lot of cases. I wish we had DNA in more cases. And I'll use a gun example, okay? We find a gun. Typically, there's multiple sources of DNA, and we can't identify the single source or develop a proper profile. So so when I look at that, I just think of, in reality, the cases we have where we have a single source of DNA, we have one of these type of cases, and we don't have a hit, and we don't have any other leads. The way I read this, I would be hard-pressed to come to the commissioner and say, we want to do a familial search when we have a suspect, but we just can't put the case together. I don't think he would say, go ahead. I think he would say, no, that's not what this policy is about. You have a suspect. The fact that you can't put together a case beyond a reasonable doubt, that's your problem, not mine. My problem is to guard this database and not let people misuse it, which has been my history with DCGIS on dealing with the database, that it's a very protected thing. So, and the other thing, when Marvin had mentioned about my comment about investigative leads, let me just clarify, and although the commissioner did clarify it, I want to clarify for myself. Investigative lead to me means the following: that the police can take that and try to follow up on it. Try to determine, okay, this person, who's related to this person or whatever. But I could never go to a grand jury, and I could never use that evidence in a trial. I couldn't call whoever ran the test at DCJS and said, who is this person related to? My understanding of this, I'd be prohibited from doing that. So, that's what I'm saying about investigative lead. It's only something that the police are going to use to look into, something like, for example, let's use the example that the commissioner used with the Capital District shootings, whatever that was, 15 years ago or whatever. If they had developed a profile for one of those people and were able to go back and say, wait a second, we've got this profile, but this person's related to somebody out in a different state, and then they would go back and say, wow, wait a second. And then you go there and say, oh, my son or my cousin or whatever the relationship is, yeah, he's missing with somebody else. We don't know where he is. To me, that would have been a great lead. And once again, I balance those against the interest that we are stepping on. So, I just thought it was important to explain that. But I can't emphasize enough. Applying to DCJS for something is not a given. It is a very cumbersome process, and it's not granted just for the asking.
I will point out we're from the state and we're here to help, though. But just one quick thing, if I could just address, because I think there is some misconceptions of how broad and vast this will be. If you look at a state like California, the first state in 2008 that actually put familial searching into effect, the population is roughly double that of New York State. The database size is roughly double that of New York State. To date, they've had 128 name requests. Of those 128 name requests, they've released 9 names. Guess what? They were 9 times the offender. So the way our policy is set up is similar but not identical to what California did. And if we're looking at population sizes and where it came out, we're not looking at a wide-scale genetic surveillance. Marvin had talked before about that this will negate regular searching and partial match searching. It will not, because the requirement of the policy is it must first be searched. It must first be in the state database. It must also be searched via partial match if it's an option. That's in the first paragraph on page 47 that we need to do that. It needs to be established. And then familial search will be an option. So the window of cases is narrowing because we're trying everything we can before we move to this level. Essentially, this is a belt and suspenders approach. You have the first time that comes out, and you go through what you have to do, which is the basic part. The second part after that is partial match if it works, but now familial search. So really, if you look at it, we've gone from having a screwdriver to having a Leatherman, a multi-tool that we can actually use, but it's not something where we're going to have wide-scale genetic surveillance. If we're looking at the other states, and I can get that data for other states, I thought California would be the most illustrative because of the size disparity, but we're looking at a state that's double the size of New York, double the size of the population, 128 searches. Since they started 9 years ago, 9 names released, 9 people that turned out to be the offender. That's pretty targeted to me. And I think that is much less than what occurs now in a normal investigation when law enforcement, trying to do their due diligence, are collecting abandoned property from a number of people. I think it was reported in the press that for the Vetrano case, there was over 500 people that had DNA samples collected and searched against that. This is much more targeted. This is much less intrusive. I think all of us are trying to weigh the pros and cons of how we do it. To me, this is a much more surgical strike.
Just a question. Just with the familial search, that'll be conducted by New York State Police Laboratory, correct?
Yes.
And then only them.
Yes.
And if there's an investigative lead, and that investigative lead does lead to the suspect will be court-ordered to give a DNA sample, and that will be done by the local laboratory. Because that's...
This policy doesn't spell out the requirement that someone goes and gets a warrant, but yes, that's the only way, having been
I think
a
my main point is that
prosecutor
familial searching will be done by New York State Laboratory.
Yes, and you're absolutely right from a practical perspective. The only way to move forward, if you get an investigative lead, you then go out and do your investigation, and that investigation develops sufficient facts in addition to that lead to provide the basis for a search warrant. Then you apply for the warrant for a sample for that person. The judge will decide whether or not you've laid out sufficient evidence in that warrant. If you have, you get your sample. There's a comparison done, and it either matches or it doesn't.
I just want to make one point, and it goes back to number 4, and I think I just want to support what DA Fitzpatrick said in terms of, going through a haplotype test, going through for a likelihood ratio. I've been doing kinship for quite some time, and, just with normal SIBship, you would on occasion get likelihood ratios that really weren't supportive enough, unless the brothers or the brother and sister, the SIBs themselves had rare alleles. Switching to the expanded FBI database, the FBI locations at this point now, and I really can't talk about the case, but we performed a kinship last week, and I've noticed the likelihood ratios have just skyrocketed. based upon the addition of the additional locations. That on top of a secondary haplotype test, whether it be YSTR or whether on female samples they decide to do mito testing and so forth, again, I don't think you're going to see a lot of names being released. And I can't say how many requests will be made, but in terms of what's being released, I think Brian, and I agree with Brian, I think it's more of a targeted approach to doing this. I mean, we had a case in Nassau County where we had over 80, 90 suspects that were samples were obtained for analysis, and I think this is a far better approach.
Yeah.
So the DNA subcommittee is going to decide what the kinship threshold is going to be for familial searches.
Again, as I read the policy the way it's written, before the state police could do any familial searching, they would have to validate the process they're going to use. They have to go back to the DNA subcommittee for approval of both the validation and the thresholds. And then if the DNA subcommittee approved, they would make a binding recommendation, and this commission would have to approve them as well before any familial searching could be done.
Do we think that's first-degree relative threshold? Is it siblings, parents, and offspring?
I guess.
Or is it cousins, uncles? I mean, is it the 50%, or are we leaving it to the lab to come up with databases that might be much lower than that?
I just don't think you're going to be able to get a likelihood ratio that's going to meet the threshold. But your question is what levels, different levels for the
what is that threshold?
Yeah, I think.
But I think the short answer is that if they come back with a threshold that we think, well, first of all, if they come back with a threshold the DNA subcommittee thinks is not appropriate, the DNA subcommittee won't approve it. And secondly, if the DNA subcommittee approves it and this commission feels it's inappropriate because it's unduly broad, it can't be done until we okay it. So at that point in time, we would have the option to send it back.
Their proposed rule change leaves it as an open term rather than saying in the rules the lab has to establish a method that will obtain a threshold of, whatever relationship. That was a question, and your answer is fine. We'll hear more about it in the future. Marvin raised this issue, or somebody raised the issue of using familial searches to exonerate the wrongfully convicted. This policy as written doesn't help someone who's wrongfully convicted, right?
No.
They're already convicted. There is no DA and police agency that's going to make a request.
In the North Carolina case, there was a familial search done which exonerated the person. This policy as written has the ability to exonerate someone who's convicted in certain circumstances.
Where exactly is that written, Mike?
How?
You have multiple offenders, and one person is convicted, and there's a sample, and a familial search is ultimately done in connection with the investigation into other offenders. And that, comes back and gives you information which exonerates the first person. But beyond that, this gives the police and the district attorney the ability to ask for the search. If information is brought to the DA's attention with regard to a potential wrongful conviction, as I read this policy, it says that the police and the district attorney can make a joint application when they believe the criteria.
Can you tell me the section you're referring to?
It's not stated in this policy. He's inferring that if
subdivision 1B,
if a defense 1B presumably came to the DA and said, is this a circumstance you're thinking, Mike? I have new evidence that this person was wrongfully convicted.
I read 1B, little or 2I, exigent circumstances. I would read that. That's why I think the or is so important, because if you had that, that's what I would come to him and say, hey, listen, I got a problem here. I'm not quite sure this guy's guilty, and I've got a sample, and
He's already
fix
been
everything else.
convicted, but you've been
He's been
convinced
convicted,
to
and based
reopen
upon
the
1-2B,
case.
you would then initiate a familial search at a defense attorney's request based upon B2, exigent circumstances?
Assuming everything else in the policy was satisfied, yes, obviously it has to be one of the crimes that's listed. Yes, if I thought somebody was not guilty and I thought it fit the policy and that we needed to do the search, yes, absolutely, I would make the application.
But we're not granting the defense bar the option of making such a request except through the DA and the police.
Yeah, and this comes
Just to be
back,
clear,
yeah, we actually spent a lot of time looking at this issue, and things in the investigatory stage are covered by this policy. Once an arrest has been made and you get into the court process, the criminal procedure law governs the exchange of information between the parties, when you can go to a judge and get an order, when you can't go to a judge and get an order. And every time we looked at that issue, we got into that, we don't have the ability to change the criminal procedure law. So honestly, from a personal standpoint, I have no objection to a process that gives the judge the ability, if you have a case where someone has been convicted and for whatever reason there was a relevant forensic sample, that was either never tested or was tested and run through the database and never identified, and there's an issue about the integrity of that conviction, and the defense feels that a familial search would help, I'm not only am I not offended, but I think it would be good policy. I just don't think we can do that. I think once there's an arrest and you get into the court process, it's the criminal procedure law that governs. And whether a judge would read their powers in 220 right now to allow them to do that or not, I don't know. But again, there would be nothing stopping the legislature from amending 220 to make specific reference to it. I would be fine with that. But I can think of a case, honestly. I had an exoneration we worked on where, there was a motion which the judge denied by the defense for testing. And even after the judge denied the motion, I sat down with my staff and said, even though the judge said we don't need to do this, I'm telling you we need to do this. And we went ahead and worked with our local lab, and we had, it was actually some cloth that had blood stains on it. We had it tested. The lab developed a DNA sample. We ran it through CODIS, and we got a hit to somebody other than the guy who had done like 7 or 9 years in prison, was still sitting in prison. We were able to take that hit and send the investigators out to the prison because that guy was doing time for another manslaughter. Initially he asked for an attorney, so I'm not talking about a lawyer. We got him a lawyer. We were able to work out a deal with the lawyer where we wouldn't use anything he said against him. And he gave us a full statement confessing to the crime, which we were able to corroborate the details of his confession with the crime. And we were able to exonerate the guy who was sitting in and ultimately convict the guy who the DNA hit came to. But in that case, if we had run that profile we got through the database and it didn't come back to anybody, I absolutely would have said if familial searching had been available, we need to take the next, we had already on our own with no compulsion under no court order for a guy who was sitting in prison, had the stuff tested, had it run through the database. Any prosecutor who's worth their salt in a situation like that, if they have familial searching, is going to say, take the next step and run it through there because I need to find out what's happening. So, that example, if we didn't get to that step, A, because we didn't have familial searching in New York, and B, because we got a match on that single source. But in the event we didn't get a match on that single source, by all means, this would have been a tool that may have allowed us to exonerate someone.
So in the definition of this exigent circumstances, not in the policy, not an aside, if you will, the rare case like that might be the kind of thing you're thinking. But to open it, you're not opening, because if there's a defense attorney involved, there is a suspect or even a convicted individual, and that that then means it's not an open case, it's not unsolved, it's not.
But if the wrong person's in jail, it is an open case.
Okay, but maybe that's a
Right.
definition that needs to get added so the defense bar knows there's access.
Under current New York law, I mean, let's say you had some, this is a crazy hypothetical. Let's say you had a DNA sample at a crime scene, and you had an eyewitness identification, say a rape victim that survived, and some idiot DA says, well, I'm not going to waste time having this evidence analyzed. I've got an eyewitness, which we all know is suspect, and I'm going with that. Under current New York law, a defense attorney can make an application to have that tested.
Yeah.
He or she can also move for post-conviction testing of DNA. And it's part of the written standards of the National DA's Association that when it goes to the issue of guilt or innocence, DNA testing should be allowed at any time in the proceeding. So to me, this would come under, quote, DNA testing.
You could interpret it that way, but I'm not sure it's clear that this access to familial searching could reside with the defense bar.
If it would assuage your concerns, and I don't do this lightly, I can speak for my 62 colleagues. I cannot envision a DA objected. It would be the height of hypocrisy to say, yeah, we really need familial searching, but it's only for us, not for the bad guys. You know,
I get. So Marvin, are you convinced that opens the door for the defense to access familial
Here's what
searching?
I'm convinced. Here's what I'm convinced of. That section 1A(b)(2), exigent circumstances exist warranting a familial search, has nothing to do with a defendant who's been convicted and is in jail. If it did, they would have said so when they wrote the policy. And in fact, I would disagree with Bill Fitzpatrick when he speaks for all 62 of his colleagues that would never refuse such a request. I can speak highly for the defense bar. I'll take that responsibility today and say that I could name 50 DAs in this state who would refuse that request and laugh me out of their office. Look, if you added in to the definition of exigent circumstances these words, nothing in this section shall preclude a district attorney and appropriate investigating police agency from requesting a familial search for a convicted defendant, that doesn't change the criminal procedure law. It's the policy with respect to familial, and it could be added in there, and we wouldn't be having this discussion. The only reason we're having the
That's
discussion...
a great suggestion, Marvin, and I, whether we, at the end of the day, send this back to the DNA subcommittee to relook at it, given our conversations, or whether we decide to make changes, I would absolutely support that language being added in.
Could you repeat it? I'm sorry.
You're supporting something I said, Mike?
It's not the first time,
You
Marvin.
broke up for a second.
I actually agree with a lot of things you say. There's just a few
Okay.
things I disagree with.
Could you repeat it again, Marvin?
Here's the language. Nothing in this section, referring to 2(b)(2), nothing in this section shall preclude an investigating police agency and appropriate district attorney from requesting a familial search for a defendant already convicted of a crime.
And just judging from Bill and Scott's reactions, I'm sensing that they support that as well.
So moved.
No
Absolutely.
way.
I support it too, very strongly.
I had a
Thank
few
you.
other comments, Mike, if I can be heard.
Please.
Everything's been said.
First, I just wanted to address a comment you made earlier, Mike, in response to my comments, in which you said, it would be irresponsible not to use familial searching as a tool. I didn't argue for that. I simply
That was just my
argued that-
opinion.
Right. I was simply arguing that there were definitions in here that needed to be changed in order for the policy to be a good policy. I never said we shouldn't have familial searching. That's number one. Number two, Mike, you haven't been in court in a long time. I'm sitting next to a respected and renowned judge. I am telling you right now that the first familial search case that leads to an investigation where the police go to some family and they get a lead to a defendant, and then that person eventually is arrested and indicted for a crime, that I will make a motion to suppress in a court of law, challenging the probable cause of the entire investigation, going back to the familial search, going back to the kinship ratio, going back to the YSTR testing, and I guarantee you I will get a motion to suppress heard. I may not win, but I will get it heard. So it's absurd to say that what we're talking about here, and this is for those members of the commission who are not steeped in the law, this kind of motion to suppress is standard in challenging scientific evidence. And we would be able to do that. And by the way, just so we're
Marvin, I think you
here,
misunderstood me because I said juries wouldn't be hearing it. I absolutely agree with you. There's no question this would be part of motion practice and potentially a hearing. It's just not going to be a jury
Michael,
issue.
the law in New York is very clear. If I win the motion to suppress, we don't have a case. It's over unless there's other evidence. If I lose the motion to suppress, under New York law, I can then introduce that evidence to a jury, and the jury can make the final decision, even if the motion to suppress was denied. That's the law.
If you as a
I can do
defense
that
attorney
now.
if you choose to put familial searching in front of a jury as the defense, you may well be right. I was speaking from the case in chief. I cannot envision a scenario where a DA would or would be allowed to put familial search evidence in their case in chief. By all means, the defense, you would have the right to put in anything you wanted. And if you wanted to bolster the DA's case,
your client's brother's a murderer? I mean,
yeah, if you wanted to bolster the DA's case by putting this in front of a jury, I don't doubt that you would have the ability to do that.
I had three more comments I wanted to make.
All right.
One about the privacy concerns that District Attorney McNamara was so concerned about, and after thinking about the privacy concerns versus those of a search warrant and agonizing over that, he came down in favor of having the policy of familial searching as enunciated in this proposed policy. Interestingly enough, as a defense attorney, I agonize over the same issues, and lo and behold, I come out always on the hand of having a search warrant, because I like to have a judge who's the impartial arbitrator come up with all the facts and decisions and then issue a search warrant for probable cause. Now, in this country, as District Attorney McNamara knows, privacy concerns go by the board when a judge in a court of law issues a search warrant. Then I have no remedy except to make a motion in a court of law to challenge that. But here, there is no search warrant. The National Association of Criminal Defense Lawyers submitted to this commission a lengthy statement on the results of a 2-year study it did, and it concluded that the best way to go was to do a search warrant. Now, you may be correct, Mike, that this commission cannot alter the criminal procedure law, and I happen to agree with you. But since this is a policy statement, then it's totally appropriate for this Commission on Forensic Science to indicate that as a matter of policy, rather than having the DCJS commissioner assume this responsibility, we would urge the legislature to amend the criminal procedure law so that a judge of competent jurisdiction can decide this under warrant requirements. And indeed, that would dovetail with the earlier remarks made by, I think it was, I can't see the individual sitting next to Pat to his right. I think that's the individual from OCME, right?
Lydia DeCastro.
Ms. DeCastro's pertinent remarks, which said, we don't have to initiate the policy wholesale, yes or no. We could phase in this policy. So one of the things we could do is put in a time period of a year or 2 years for the DCJS commissioner to be the person who's going to make the final decision, but in the meantime, have the commission adopt as a policy that we would prefer a judge of competent jurisdiction to decide these issues in a court of law pursuant to warrant requirements. I don't see any problem with that. Finally, the last thing I wanted to talk about was training. I think in the familial search policy, Mike, there is a section on training. I may be wrong about that.
No, there is.
Yes.
There is, right? So the section on training says that the people who are going to do this kind of work on familial searching have to be trained. And there's a footnote, I think it's item number 5, reporting familial DNA search results. And it's 5AB, small I, parts 1, 2, and 3, including footnote number 1 on that page. This requires that training be done of these individuals who are going to do this kind of work. And it says that the training may be provided by video conference at the discretion of the commission. Do I take that to mean that if we enact this policy, you already have in the works a training program that will be conducted by the state of New York under your auspices for people at the New York State Police Laboratory, where the search is going to be done, and that is already in the works? You have a plan, you have a curriculum, and you're ready to go? Or does the policy as enunciated in section 5B, small I, parts 1, 2, and 3, mean that the New York State Police Laboratory will do its own training, and they will decide how much training, what kind of training, what the curriculum will be, how it will be implemented, and how people will be certified?
Yeah, I may not be understanding you right, but as I read 5BI in the 1, 2, 3, 4, and 5 under it, the training is training for the district attorney, the police agency, and the local lab to ensure, to the extent that we can, that familial search results are not misused. So it would be training for the people prior to any release of any familial search information or results, the people who are going to be using that. So the investigative agency, particular investigators assigned to the case, the DA and or the assistant DA who's handling the case,
right.
Someone from the local lab would be trained on exactly what familial search is, what the limitations of it are, how the familial search leads should be used, specifically geared toward issues of protecting unknown family relationships like adoptions, previously unknown relatives. They'd be trained on the requirements associated generally with DNA profiles contained in Executive Law 995. They would be specifically trained on the requirement to withdraw a request if a suspect is identified, and they'd be trained on the requirement to regularly provide follow-up information to DCJS so that we as a commission can monitor what's happening with any familial search information we give out. By the plan, as I read the plan, every 2 years we're required to revisit this policy, and I think it would be very important in that revisiting for us to know exactly what happened or what is happening with each of the leads. So that the training is not for the lab personnel. The training is for anyone who we're going to release familial search results to. They would have to get this training prior to that release.
Let me just follow up, Michael, and ask you this question. This training that you referred to in Section 5 for what is, I think the term used is requestors. I assume that means police and district attorneys, or just district attorneys?
No, both.
And if it's both, how does it work in terms of the detail? if I'm a DA in County X, I have to have a designated person in my office, a DA, and I have to recommend, or the police in that county have to come to DCJS and request this training, and you certify them? Is that how it works?
I am not envisioning that this is training that happens, where you get someone trained and they're trained forever. I'm envisioning that immediately prior to the release of a result in a particular case, the people working that case have to come up and get that training, and we don't release the familial search results until we know that the people who we're going to release the results to and who are going to be working that case have had the training. So I don't envision that, for example, the Rochester Police Department, the Monroe County DA's office gets somebody trained tomorrow, and that training is good forever. I envision this to be, and every time we're going to release results, those people we're going to release them to have to come and get that training.
Fair enough. Would that also apply to those situations where you're acting in exigent circumstances which exist, such as the example you gave of the knife-wielding slasher who can't be caught? You would then order a familial search, assuming that we could get a memorandum of understanding done quickly enough. You would authorize a familial search, and then if it hit and you got some of the investigation in that short period of time where you'd be working very quickly, you would then, before you decided to release the name, you would have people under those exigent circumstances from, say, Bill Fitzpatrick's office come up to DCJS along with a police officer from Onondaga County, and they would receive this training. And let me just follow that one up with, do you envision this training to be formal training where you sit in a room and you're lectured to, or are you going to give them a pamphlet and said, read this pamphlet, this is what you got to do?
It's not going to be a pamphlet, and I think the scenario you described is one of the reasons why you have the footnote. If it's exigent circumstances, time is of the essence, and rather than driving to DCJS and back, we want to set up a video conference, but it's absolutely not a pamphlet. There will be a formal training curriculum, and the training will either be delivered in person or by video conference.
And final question, have you started to work on this? Has this curriculum been worked out, or it's just an idea at the moment?
We've looked at other states that require training and looked at the training that they do. We don't have a curriculum finalized yet.
Thank you.
In light of your response about when do you do this and how often and who, we might consider suggesting inclusion of language there under 5B. Requesters are required to satisfactorily complete and demonstrate a mandatory in-person training prior to the release of each such search result, because that's what you said. Every time you're about to give them information, and I don't, the video conference or in-person is fine. It's 5B.
I think our intent, I agree with you, our intent was that was encompassed by C, in that, as I read C, the results cannot be released until the requesters have completed and demonstrated an understanding of the training.
That could still imply a one-time, I've checked it off, it's on my resume.
Sure, yeah, no, the wording can be tightened up.
If you mean each time, then I think it should say each time. And then regarding this, you're going to research the database at least every 2 years for as long as the case is open. I always advise programs looking at laboratory data, never do a research, never do a reanalysis without a request to do so. So, because the onus is then on who? On the lab, on the database, right? So I would suggest that, that upon submission of a request certified by DA and the police department, they will be researched as often as every 2 years.
Something, oh, sorry.
You should ask for them to tell you they want you to do it, rather than asking them to tell you if they don't need it anymore. Make it a proactive. They want it again in 2 years, they can ask for it again in 2 years.
Just a quick thing. Maybe it's because in the UK it might be different, or maybe my understanding, but I read biannually is every 6 months, twice a year.
Yeah,
Not every 2 years.
I think he meant every 2 years, didn't he? Biennial
I
or
thought that
biannual?
But do you think so?
No.
It's every 6 months.
I think this is supposed to be.
It says biannual is twice a year, every 6 months.
Okay.
If he means biennial,
That's it.
so then it's every 2 years. Whatever you mean, but you need to get a new request.
Are you making that motion there, Ann, prior to release of the search result under 5B?
Yeah, it's language that I think should go back to the committee.
I think we have a couple of choices here. One is, we could go through and, make changes. I think the second thing we could do is send this back to the DNA subcommittee for them to consider all of the discussion we've had and the recommendations we've made, specifically highlighting, Marvin's language and indicating that all of the commission members, I think I speak for all of us, felt that that was important. Highlight yours, but ask them to look at all of our comments and send us back something in light of all of the input that we've given them at this meeting.
I think that latter is fine. You give them the transcript of the discussion and say, consider the discussion and we want to see it again.
And Judge or Marvin, thoughts on which of those ways we proceed?
I think the method you just described, where we just send back to the DNA subcommittee the entire proceedings here today, and let them absorb that and see what will happen. It would be helpful, Michael, if the DNA subcommittee meeting, when it has its next meeting, because it has its own bylaws, would, in the course of considering what we said here today, hear further information from the public in terms of the things that they're considering based on today. That has been a problem in the past, limiting speakers to 2 or 3 minutes on very complicated issues. Perhaps you could use your good offices to encourage the chair of the DNA subcommittee to sit still along with the other DNA commissioners to hear me or Mr. Scheck for 5 minutes each.
I will certainly make that request and talk with him, and I don't think 5 minutes, given the nature of this, would be unreasonable.
Can I ask though, as Commissioner Scheckter said, this started off with a letter back in December 2016. And again, it seems we're moving it back to the committee. Is the committee going to give a binding recommendation that we can vote on? Or are we going to then proceed, because it's, as you had said, and well, he'd said about the kinship, are we going to have kinship binding agreements by that time also? Should they be working on that contemporaneously? It just seems that time is passing us by.
So I guess in response to the first question, I would anticipate if we send it back to the DNA subcommittee that they would consider this at their May meeting, and at the end of that meeting they would make a binding recommendation. They would vote, and the result of that would be a binding recommendation. It would come back to the commission for our consideration at the June meeting. I don't see this as a never-ending process.
I agree with the implication of Scott's question. I don't think we need to keep kicking this can down the road and have more hearings. I would suggest amending 1D to include the language that Marvin suggested, to amend 5B to include the language that Ann Lilly suggested. And the only suggestion I have in terms of an amendment is on page 55. I think this is in the rules and regs. It under 2 Roman numeral I, it says, if upon review and evaluation, et cetera, requirements are not satisfied, the division shall notify the requestors in writing that a familial search cannot be performed The only suggestion is that I would ask is that when that denial is returned to the requesters in writing, that the reasons be given to some degree, so there's a deficiency and it's possible to correct. The requesters will have knowledge of what it is that needs to be corrected. I don't know if anybody else has any amendments or any comments, but
So let's just start with those three.
Before we go to that, actually, sorry, that's page 48, C1, is that same part that's carried into the reg change. So if you look in the policy, that's,
I've got page 55.
That's in the right.
What he's saying is if you look in the policy,
It's in the policy.
It's in the
it's
policy.
48C1.
3CI.
Yeah, three,
Here's one. Oh, yeah, I was
you're
looking
right,
for that. I couldn't find it yet.
3CI.
Yeah, so to amend both those.
right.
Add that. I think if we can start with the policy, make the amendments there, and then we'll just assume that we're going to make conforming amendments all the way through to both the regs and the plan.
And I think these three amendments are policy, not science
Yeah.
discussion.
No, so the three amendments that Bill just outlined, Marvin's amendment to 1B2, Ann's amendment to 5B, and then Bill's amendment to 3CI. Does anyone have any further discussion or objection to any of those three amendments? Just dealing with
No
those three.
objections to those, but there's the additional,
I won't preclude others. I'm just saying.
Oh, okay.
Yeah,
No
let's see if we
objection
can
to
get
those.
things off the plate, and then this is not the end of anything. I'm just saying with those three, is everyone in agreement that we should make those three amendments?
Yeah.
Whatever else we do.
Yes.
Marvin, that was the
Yes.
right place for yours? I somehow put it under A, but you had it under 1B? Your wording?
His was under.
It's under
Okay.
1B2.
Under exigent, perfect. Okay, thank you.
Can I just ask in that regard?
Yeah.
If you don't mind, just that the defence would make an application. with
No.
it's
Still the DA and the police chief
Okay.
making an application. It's just specifying that they can make that application in a case where someone has already been convicted. It's explicitly including that
Okay.
in the basis for an application. All right, then
Mike,
there's no
Michael,
yes,
can I ask you just a question?
Absolutely.
These three amendments that we just all agreed to, they're not dispositive of the rest of the discussion today.
No.
I wouldn't want this to go back to the DNA subcommittee and they say, well, you only recommended three amendments, everything else you discussed, you didn't recommend amendments on that, so we're not changing that.
Now, as soon as we vote on this, I'm going to open up for further discussion. We can take other votes. I just want to get these, if we can get issues off the table and at least make some progress moving forward. But yeah, we can address anything else. So just with regard to those three, do I have a motion to recommend to the DNA subcommittee that they make those three changes consistent with our conversations here and with what Bill outlined? All right, Scott, you're moving. Do we have a second?
Second.
Okay. Lydia, all in favor? Anyone opposed? All right, so that's unanimous. All right, now, other suggestions, thoughts, motions, items?
Well, with respect to case requirements 1A4, crime presenting a significant public safety threat, that the DNA subcommittee consider more specific language to define significant public safety threat. Just want them to consider it. The way it stands now, I think, you've given us some examples. I want to be sure that it matches the examples that you give, and that's not expanded by some DA somewhere to include something that's a significant public threat to him, like Fluffy the dog, but not to the rest of us. So that's my request.
Other requests, comments, suggestions?
Yes,
we got the training as being prior to each release, right?
Yes, that was your...
Okay. And then did we get in 5C upon submission of a re-request or re-certification? The sample will be searched again?
No, I don't think we.
No, we didn't do that.
No.
We did
We didn't
not.
do that.
No.
How do people feel about that? You know,
I think it's a good idea.
And it's every 6 months, not every 2 years, because I think, I was getting
Well,
confused.
I don't care. It's upon that request.
and the request can't be made at least 6 months after
Right,
pass
it has to
before
be
the
at least
request
every
can be
6
made.
yeah.
No less than.
All
You
right.
can't request in less than 6 months.
So is everyone good with indicating to the subcommittee that we want them to change the language with regard to requests so that there has to be a request for a research or a new search to be done, and that it can't be done any sooner than 6 months, at least 6 months after
Yeah,
it passed.
yeah.
Yeah, that's it.
Yeah.
All right. So
I
then,
don't understand that. Why would we have to wait 6 months? What would be the reason for that?
I think I guess for one, just is a question of economy. You know, you do a familial search and it does not come up with anything that meets the threshold indicating that there may be an investigative lead. You know, do we want to make the state police do these every month or every 2 weeks? Or I see Ray over here indicating, but I think.
Well, does the whole, are you saying that the whole process of the application would be redone at,
No,
to get the
not that the application would be redone, but the state police would have to do the search.
Yeah,
Maybe
I
Ray,
can
you
provide some details. So roughly 3,000 to 4,000.
Can I just ask you to come up to the table? Because I just don't know how good our microphones are, and I want to make sure people in New York can hear.
If you could just identify yourself also.
Sure. My name is Ray Wickenheiser. I'm the director of New York State Police Crime Lab System. To just provide some information, the reason for doing the research to search again would be to capture new offenders, new candidates as they're coming into the system. On a monthly basis, roughly 3,000 to 4,000 new individuals would go into that database. That would be the reason to do it again. Now, that lift would be considerably less if you consider the first search does over 600,000 potentially. So to redo it again, you just would have that opportunity that as new offenders come in, if it's one of these crimes you really want to pursue an investigative lead, that would be why you would do it.
Let me ask
there
for
is
the
a
judge's point, though. You know, is there a reason why we should say you've got to wait at least 6 months? There's got to be a 6 month interval before you retest, or you know, if it was appropriate in the case to check the new ones every month. You know, what from a work perspective from the state police is practical?
Right. To me, that would be a matter of, to me, it's a which comes first, the chicken or the egg. I would rather have the policy, you determine what you feel is right, and then we would try to match that. So if there was a huge, very critical public safety issue, we would try to realign what we did and try to do it more quickly, that maybe a monthly would be more appropriate. So I think to me, it's a matter of more what's appropriate to the case, as opposed to somehow locking in that someone has to wait 6 months to pile up that amount of time, which, you know, artificially I think would jeopardize public safety. So I'd rather put it in terms of a policy and provide some flexibility. I think 6 months is maybe reasonable, but to me there might be cases that would dictate a little more urgency.
shouldn't it be at a 6 month interval or at the discretion of the commissioner? If cause is shown or something like that, to give the commissioner some discretion to order it to be done before the 6 month interval?
I think given what Ray has just said, that makes sense to me.
Right.
Good idea.
Good idea, Judge.
Can I ask a question? Is it clear here that they'll get a negative result? Because I know we talk about positive results from the familial search. So does the agency get a negative response, or because they haven't received a response, they can assume it's negative? And if they assume it's negative, what's an appropriate length of time? And again, not to put it on Ray, his turnaround time for that familial search. So I'm assuming you would have to do a negative response also
I
to
think,
each of these. I just know it's not delineated. I'm sure you would not.
as I read 5C2,
Okay.
I believe they would be told that there was no.
Yeah.
Oh, I'm sorry.
Notify.
I apologize. I
Yeah.
didn't see that.
Letter going to,
No, my mistake.
All right, so, again, I don't know that we need to wordsmith this because we're sending it back to the DNA subcommittee, but is everyone comfortable sending this back with a recommendation that under 5C2, and specifically 1 and 2, that the discussions we've had indicating that new or researches should only be done upon application. Generally speaking, should only be done applications should only be made every 6 months, but in the event there's circumstances that justify a search more often, that application can be made, with the reasons therefore set out, something to that effect. Is everyone comfortable making that recommendation to the DNA subcommittee?
Yes.
Just so I understand, I apologize. So it's no longer going to be autonomous. It'll have to be a re-application in terms of the
Not a whole application. I don't.
No, it's just a recertification, but they say they still need it.
Okay.
Yeah.
Because something could have happened, like the case in New York City. It could have been solved in the meantime.
Right.
And that's part of, they do have to let us know under this policy
Yeah,
and part of the training. So but they would just say, look, this is
They have
still
to ask for it
open.
again.
Everything we said in the application is still valid, and we're asking you to run this again.
So it's not
Wouldn't
as
it-
if
wouldn't it,
there has to be some rule on expungement or anything like that to remove it, or you call
No,
up
because
on-
it's not automatically being run. They have to ask for it.
Okay.
I think that was your point.
Yeah, they have to ask you to do it again.
Is
Who
it's
has to
easier to have
ask
the
you?
man.
The DA
I don't
and the police
understand.
department.
We've set out in this policy a very specific way for the request and the application to be made. Now you're talking about a different kind of application. And it's unclear to me what would be required to get this going again. Another agreement between the DA and the investigatory agency, just the DA, or would it be better to require to allow them to redo it at 6 month intervals or at the discretion of the commissioner? Something, because what you're talking about now is a whole new application process.
And I don't think that's what we mean, so we could say in the format as specified by the commissioner. It's a recertification. It's not a new application. It's a letter, perhaps jointly signed by the two, saying for all the reasons we asked the last time, and under the agreement we already have, we'd like you to look again. But we could say... But what we're saying is that the database doesn't have to automatically do it every 6 months. They have to wait.
I understand that, but to me, you're adding a cumbersome layer here that I would think is unnecessary. If the showing has been made that the familial search is required, is necessary, and then to redo it at a specific every 6 months, to me would make sense, or at the discretion of the commissioner at an earlier date. But to require a reapplication, I think is...
It could just be a letter saying that you approved our search. We could have a form letter. It's been 6 months. Please have this researched. And then there could be a second part of it that says, it was less than 6 months, but we believe you should do it more often because of fill in the blank. And, so it could be very simple.
That's going to have to be laid out here then, that process, so that people are on notice as to how to do it.
In the method as prescribed by the agency, just like the original application is in the method as prescribed by the agency. There's no detail.
Well, there is some detail, but anyway.
Well, but in the form and manner required by. It doesn't say...
All right, so we in agreement that we'll send it back to the DNA subcommittee
Have them consider
again on this issue, with the recommendation that to get the same search that was approved done again, that there has to be a request that generally speaking every 6 months, but if there's reasons why it should be done more often, and that there will be a form or a process that will be very simple, that won't involve redoing the whole application or the whole process. All right. So we have a motion on that, Scott. Do we have a second?
I'll second.
All right. All in favor?
Aye.
All right. And anyone opposed? All right, other specific areas that we want to highlight aside from our general conversations for the subcommittee?
Subsection, part
Go
one.
ahead.
Sorry, Marvin, just as you were saying about the next time the DNA subcommittee might meet, we'll take our considerations and might and come back with a binding agreement. But I also see, again, trying not to kick it down the road, is it possible to discuss having them moving forward with coming up with the kinship threshold values, just so we can have that as we're going along. I'd not like to then vote, and if the vote goes a certain way, now we need to wait another 3 to 6 months for the kinship threshold value.
Ray,
They're separate processes.
do you want to speak at all, and I don't want to put you on the spot, if you don't, that's fine. Do you want to speak at all to where you are with the process or not yet? If you don't feel any.
Yeah, and certainly, we don't want to get ahead of policy in any regard, but we've had a look and our validation is in process. Certainly, it's working well, and we would be, flexible in terms of certainly. There's a lot of work that has gone into it, and yet has to be done. So we'd be flexible. We could go parallel if need be, or we can wait. But certainly, I don't want to get ahead of the policy.
But the binding policy can't be implemented in any way until we resolve the threshold level, right?
I'll just say that we can put our resources to providing information at the next DNA subcommittee as to what threshold values could be considered. We can do that.
So I guess to your point then, Scott, if the state police is ready to do that.
And again, I'm sorry to interrupt. I don't want to get ahead of our folks. I'll just say we can endeavor to do that and try to do that.
That's what I'm saying. If the state police is ready to do that by the time of the next DNA subcommittee meeting, we'll ask the DNA subcommittee, to hear what they have to say and to consider that issue. If they're not ready to do it, we'll ask them to consider the rest of the policy and then get to that issue when they're ready. Because, again, I appreciate the work you're doing. And I don't want to, in any way impose any unreasonable time constraints. So if it's reasonable and it works, great. And if not, then we need to give it the time that it needs. It would be, at least that's my position. I don't know.
Yeah, I don't mean to impose any time constraints on Ray or his staff. It's just I want to make sure that, we discuss it.
Sure.
What's the date of the next DNA subcommittee? Do you know?
If it's May 19th, I'll double check while we're talking. I just got a nod from Shelley, so that means yes. She's better at this than I am. Marvin?
Yes, with respect to page 47, section 1 case requirements, subsection B, I, and 2I, that the DNA subcommittee consider more specific language for sections B1 and B2 to define reasonable investigative efforts and to define exigent circumstances. Just to leave it the way it is, I think it's wide open. It may very well be that they will refuse, which is fine. It may very well be that after thinking about it, having it pointed out by us, they might come up with a little bit more specific language. In any case, it can't hurt because in the end, it's all coming back to the Commission on Forensic Science for final approval.
And I guess what I would say is that, while my initial reaction is that I think a lot of work was done, to get the language to where it is, I tend to agree with you that it can't hurt to ask them to consider it with the understanding that they may or may not find ways to narrow it. So, for that reason and seeing that it's worded in terms of asking them to consider the language, I would agree with you and, highlight those areas for their consideration. I don't know, other people.
Marvin brought up 1A4, crime presenting a significant public safety threat, and 1B, 1 and 2, with all due respect to the DNA subcommittee, these are policy matters, they're not scientific issues. I'm happy with the language, but I'm also happy with your suggestion that they take another look at it. But if they're going to review this, my suggestion would be leave it as is.
Yeah, no, again, my initial reaction is as yours is. I think a lot of time went into this. I think they balanced well, but I also Marvin phrased it in terms of asking them to consider, and I don't see any harm in doing it.
No.
All right, is everyone in agreement that we'll ask the DNA subcommittee to look at and consider the language in 1A4, 1B1, and 1B2, with the understanding they may or may not change it?
Yes.
All right. Do we have a motion on that? Marvin, you want to make that motion?
I
Do we have
do.
a second? All right, we have a second. Everyone in favor?
Aye.
Anyone opposed? All right, anything else with regard to the policy? All right, if there's nothing else, as to the regs, understanding that we will ask the DNA subcommittee anytime they make changes in the policy consistent with what we've recommended or discussed, we will ask them to make the corresponding changes to the regs and to the plan. So with that understanding, is there anything in addition with regard to either the regs or the plan that people want to discuss?
I have just a general comment, Mike.
Sure.
I saw in the original letter from Mr. Adams, or Dr. Adams, to the commission that the way the policy was developed was that the DNA subcommittee met in groups of 2s and 3s, were assisted by the Office of Forensic Services. So I have no problem with the meeting of people in groups of 2, because I think the open government statute is not violated when 2 members of the DNA subcommittee or 2 members of this commission talk to one another about a particular issue. On the other hand, once you go above 2 into groups of 3, that is a violation of the open government law, and it stymies the purpose.
Actually, it's not. A quorum is 4.
I'm sorry?
A quorum of the DNA subcommittee is 4 members, and that's what would be violative. So they didn't meet in a quorum.
I'm not addressing the issue of quorum. I'm addressing what the intent of the statute was. If 2 or 3
well, the
members,
intent of the statute is that they can't meet in a quorum.
right.
So
But
just like this.
What they can't do is meet groups of 3, discuss the matter, and then bring the results of that conclusion to a full quorum of the DNA subcommittee, and thereby scrub clean what was not permitted by the statute. My purpose for making this comment is that I think you tread very dangerously upon violation of that statute. And to the extent that you do, it poisons the DNA subcommittee's recommendation to us. After all, if 3 members of this commission could meet privately in a room and reach a conclusion about anything that we discussed here today, and then the 3 of us came to a full meeting and the entire commission voted on it, the entire commission's vote with a quorum present doesn't retrograde, scrub clean the violation of the open government law. I suggest strongly that the Office of Forensic Services not engage in these meetings of 3 people and 2 people. I think it's just not a good idea, because we don't have the minutes or notes of those meetings. We don't know what was discussed. We don't know how policy conclusions were reached. I, for one, for example, don't understand if the DNA subcommittee, when they made this policy, whether or not everybody was in agreement or whether or not there were dissenting voices. I don't understand who the groups of 3 were. I don't know how many of them there were. I think it's not a good idea to do that. That's my observation, and you can take it for what it's worth, but now it's on the record, and I hope it doesn't continue.
Well, thank you, Marvin. And what I could say is that my recollection is that this commission directed the DCJS and or the Office of Forensic Services to work with and assist the DNA subcommittee in the development of a draft policy. In trying to do that job and do it well, they couldn't do it in a vacuum without input from the subcommittee members, but we're also very aware of and tried to be very careful not to violate the open meeting law, which I read to say that you couldn't meet or consult with them in a group of 4 or more. So, I think we did and tried to do to the best of our ability exactly what this commission asked us to do, and did it in a way that didn't violate the open meeting laws. And at the end of the day, all of the discussion of the DNA subcommittee itself was done at their meeting, on the record, open to public scrutiny. The vote, again, was on the record at the meeting and available to public scrutiny. So I certainly appreciate your comments. We'll keep them in mind going forward, but by the same time, we were trying to do, and the Office of Forensic Services were trying to do what this commission asked them to do in the best way possible. So, all right, if we don't have any other comments, what I would ask is just as a whole that we take a vote. We've taken specific votes flagging or highlighting certain areas, but I think as a whole, I would make a motion that we send the entire policy, regs, and plan back to the DNA subcommittee, ask them to consider the entire policy, regs, and plan in light of the specific recommendations we've made to them in terms of our votes, in light of the overall conversation that we've had, and as soon as possible, send us back a binding recommendation with regard to the issue of familial search, and specifically a policy, regs, and a plan.
One friendly amendment, Mr. Chairman, that they adopt the 4 amendments that we voted on, and that the other thing they consider are the recommendations concerning the 3 matters that are on the record.
Okay, I'm fine with that. So with that understanding, do we have a motion?
So moved.
Do we have a second? Any other discussion? All right, all in favor?
Aye.
Aye.
All right, anyone opposed? All right. Thank you. Certainly, I know this is an area where people have differences of opinion or have different points of view, and I certainly appreciate the work that everyone has done on it. I appreciate everyone, professionally articulating your points of view. I think we've had a very good discussion on this, and I just want to let everyone know that I appreciate the work that you've done on it and the way that we're able to discuss these issues. I think we do have some other business on the agenda. If I'm not mistaken, the next item we have, I think we have one other item under old business, if I'm not mistaken, Brian, is that right?
That's basically the comparison accreditation.
All right, and that relates to kind of an ongoing discussion we've had about the comparison of the different accreditation programs. We've been looking at a number of different programs. I think where we left off last was we're trying to get ASCLD Lab, which is now, ANAB, to come to the commission and make a presentation. For logistical reasons, that didn't work out, so I believe we're going to have them at our June meeting. Is that correct?
That's correct. And the standards that they actually have been pushed out. So at that point, I'm going to distribute those standards, those additional standards to commission members to look at and review. So in advance of the June meeting.
So in addition to the familial search, if the DNA subcommittee sends it back to us, we'll also have ASCLD Lab / ANAB here for the June meeting. So to the extent people have questions for them, either as to the new standards they have, or generally as to their program, come prepared to speak with them and ask them those questions at the June meeting.
Michael?
I'm sorry,
resolution,
right after Ann.
Any resolution of this new business relationship and whether ASCLD Lab is still an independent, or are they assumed under, or we'll find that out in June?
Yeah, my understanding is that ANAB is the parent company, and ASCLD Lab is now it's like a subsidiary of that, but I think that'd be most appropriate to actually ask them.
In June, okay.
Marvin.
Have we had any contact with ANAB since the last meeting of the commission to today regarding the concerns that Brian Gestring raised about some of the new rules that they had that wouldn't fly in New York?
We spoke to them, and we sent a letter from the commission to them, and we'll provide that next time, essentially giving the excerpt of our commission meeting in December, so that they could actually look at and review our comments, and they did take those comments into consideration when they made their amendments to their supplemental standards. So you can see, but that was conveyed to them, and they did in fact take it into account.
Just for the record, as I understand it, Asclad Lab no longer exists. It was bought out completely by ANAB, and it was reduced to being a special advisory board to ANAB. But as an entity, it no longer exists.
And I don't disagree with you at all, and I think those would be very good and pointed questions to ask them when they come here for our June meeting, and hopefully we'll get some definitive answers from them that will help us decide how we want to move forward. All right, the next item we have deals with accreditation and laboratory updates. Brian, do you want to take us through those?
Sure. And the first one we have is actually the Nassau County Laboratory. So back in October, there was underwent a expanded surveillance visit. So you have the documents in your binder. It's page 15 through 29 in the binder. Dr. Buffalino is obviously here if there's any specific questions you have for him. Actually, and also Deputy Director or Assistant Director? Assistant Director. He's going to promote her soon, right? Karen Dooling is in New York City also if there's any questions. All right. Hearing none, the next one is the New York City Police Laboratory. We have Dr. O'Neill up here. You'll notice on the agenda also we started putting page numbers for commission members to look around. So you see a page numbers in a different color. That means it's an additional document. It's not in your binder. So it'll be page number 139. So they just have a operations change, and they were just making a notification about that. Okay. Next one is the New York State Police Laboratory. A similar type of thing. They have a change in their management structure. Pages 31 to 33 within your binders. And we have, as you heard, Ray Wickenheiser here, the director of that laboratory system. Okay, the next one is the Niagara County Sheriff's Department, pages 35 to 41 of your binders. And they had also a expanded surveillance visit. And I believe, if necessary, we don't have a member at either location, but we have phone contact if we need to reach out or clarify any issues from that. Okay. Hearing none, it's back for lab disclosures.
And thank you for the page numbers.
Just makes it a little easier. First advance was getting rid of the physical binder and moving to this, but the page numbers I think are helpful.
All right, so the next item, we're at number 6, are lab disclosures. And again, Brian, you want to take us through the lab disclosures?
Sure, and in your binders, pages 83 to 85, there's a disclosure from the DCJS Latent Print Laboratory, and we have the director of that laboratory if anyone has any questions.
I have a question.
Maybe you can just identify yourself so that everyone knows who you are.
My name is Bharat Lakhar, and I'm the director of the Latent Print Laboratory. Oh, New York State DCJ.
We can't see this person.
Hey, if he moves down next to Shelley, can you see him?
He doesn't bite anymore.
Here we go.
Still can't see.
Still can't see him.
Yeah.
All right, why don't you,
It's like cropping a photograph. Maybe we could Photoshop it.
I know.
how about now?
Great.
Good.
Okay, your question?
Yeah, Director, can you just sort of fill me in here? This looked like a fairly routine, everyday kind of thing that would occur in a lab. So I'm a little puzzled by the report that the examiners received a notification of potential match and then incorrectly concluded it didn't match, then changed it again. Isn't there a protocol already in place to deal with this kind of situation?
This is basically a non-conformance in the sense that you are expected to identify it. Let me just explain to you the situation. What happens is, similar to DNA profiles, when you put the images into a database first to try to generate matches, it generates certain matches, you look through all of them and then conclude, the analyst concluded here that there was no match, which was correct conclusion. But if there is no match and it's an unsolved case, the case remains in the database and keeps on getting searched constantly. And from time to time, in fact, every day they get numerous search candidates from the database to actually go and look at them. So when the analyst looked at one of the candidates which were generated by SABIS, which is the state database, he concluded wrongly that it was not a match. Subsequently, the supervisor of the analyst came across a similar match with the FBI database. And the supervisor asked the analyst to go back and take a look at it again. And when the analyst took a look at the FBI generated candidate, he came to the correct conclusion that yes, it was a match. And now what happens is, since these database search results keep on coming constantly, in case the conclusion is not that of a match, no report gets generated, because otherwise you will report hundreds of such reports. And since there's no report that gets issued, such kind of cases do not undergo any kind of review. Because it's a negative result, no additional report is being issued. So unfortunately, these kind of comparisons do not get evaluated if they give negative results. If it's a positive match, naturally there'll be a report, it'll undergo all the reviews and everything. So in this case, an incorrect conclusion was reached. Subsequently, when the supervisor was reviewing the positive identification next time, the supervisor realized that in the past, the person had incorrectly identified something. So when we reviewed this situation, we were not sure if we really needed to report this within 30 days to the commission, because this is a typical case of false negative, and generally, according to Askeladd Labs' different guidelines, it does not fall into that criteria where we need to let the commission or Askeladd Lab know immediately within 30 days. But when we realized that in this case 4 or 5 months had passed by the time we issued the correct report, it could prove to be significant that some particular person would be roaming around there and might commit some other crime. So it could be significant. So we decided to disclose this within 30-day time period, even though we are not sure if we were really required to do it.
Are you going to change your procedures for dealing with false negatives?
Yes. In fact, we have just instituted a review for each of these negatives. The problem is these are very numerous, so we'll have to closely watch, because in a year, from what I have heard from the software people, there's about 110,000 candidates which get generated. And out of that, only about 460 or so are positive. So what tends to happen is you are looking at these every day, and it's all negatives, and 1 out of 200 come out to be positive. So that was one of the main problems. Every day you're looking at 10 or 15, and everything is a negative. So that's why we were trying to, in fact, we have partly completed the corrective action. One part I just explained to you, that we are going to institute the review and see how it goes. But the second part also is we are trying to see if we can raise the threshold so that so many false positives don't come out, so that analysts every day are looking at, for 4 months they are looking every day at these images, everything is negative, and then they come out with one positive. But raising this threshold is a complex issue because we don't really own this. This is owned by another agency in DCJS, and that could affect the whole state. So recently they changed the software, and we are going to try to review the data. by the end of May and try to see if we can raise the threshold so that so many unnecessary false positives don't have to be looked at in the whole state.
If I can just add, Marvin, with regard to that threshold, for me, one of the concerns was, I want to put the threshold at a level that gets rid of as many false negatives as we can, but I don't want to put it at a place where we eliminate any positives. So we're just trying to be very careful, that we change the threshold and get it to a spot that eliminates as many negatives as we can without taking the chance that we eliminate a match by doing that.
Okay, thank you.
Mike, I have one question.
Sure.
When you had the state level notification, it says that the examiner received the notification. But then when you had the FBI level, it said the supervisor also received a similar notification. So
I think what happens is when the notification comes from SABIS, it comes directly into the queue of the analyst.
Okay.
Whereas with FBI, it's a slightly complex process. So a supervisor reviews them and tries to see which particular notifications belong to which analyst.
Is there a way to include the supervisor, or is there
Anyway, it could go
any way
directly to the
to have the
analyst.
supervisor also included in that state notification, or is that just part of the way it works?
I will have to look into it.
Okay.
I'm not sure about it.
Thank you.
So the next disclosures from the Erie County Department of Central Police Services, page 87 to 91 in your binders. We have the lab director in Albany if you have any questions.
Question.
Dr. Simich, if you don't mind sitting on the far end of the table, it seems to be, so you're not in the witness protection program on this side.
Doctor, have we found the 410 gauge shotgun? And if not, where do we think it is?
Well, we have not found the shotgun. It is missing. We have done a complete inventory, and we have no hypotheses as to what happened to it. We've done a thorough investigation. We don't feel there's any intentional wrongdoing, and anything else would just be conjecture.
Has it caused you to change any of your procedures?
Yes, it has. We had actually already instituted some changes prior to this, just to improve our inventory and recording of that particular type of asset. So all parts of a firearm submission now get a sub-item number. Back in 2009, just the case that this came in was given a number. That policy was actually instituted probably a couple of years ago as a routine matter, just to improve the overall process before we even knew there was any type of a problem with it. And we are also going to be requiring a more thorough review of what is being released before it is released. Our release of firearms, Erie County is historically tasked with destroying firearms that were submitted by the Buffalo Police Department. In any given year, that could be probably around 500 to 700 weapons. And we were in the process of doing 2009. We were a little bit backlogged on that. And that's where this firearm was from. So moving forward, we are going to be instituting very soon the process of actually returning those guns to Buffalo when we are done with the analysis. I don't know how many we will be returning. We're going to start with the newer cases, let's say 2017, and then begin to work backwards so we are no longer the custodian for Buffalo guns. So hopefully in the future that will not be, we won't have a large inventory of firearms in our possession that are moved around and juggled to make space and things like that, and those can contribute to having things get misplaced or lost.
Thank you.
All right, thank you, Dr. Simic. The next disclosure is from the New York City Office of Chief Medical Examiner, Forensic Toxicology Laboratory, pages 93 to 96 in your binders. I believe Dr. Cooper's in New York City if there's any questions.
Question. Good morning.
Louis Vargas, QA Director for the agency.
Dr. Gail Cooper, Director of the lab.
Welcome.
Thank you.
So, simple question. You may not be able to answer it yet because I see there's a root cause analysis being done. Has the root cause analysis been completed?
No, the investigation is still ongoing and the meeting itself is scheduled for May 4th.
Okay. I just want to make sure I understand what was written so far in the letter of March 30th, 2017 to Council Speaker Melissa Mark Viverito and Council Member Corey Johnson. And correct me if I'm wrong. There was a laboratory report that was completed with respect to testing, and report included results for decomposition fluid, whatever that is, bile, and vitreous humor. 3 things. The laboratory report was received. The medical examiner emailed the laboratory and inquired about the significance of the bile result. A day later, February 14th, 2017, it was discovered that a bile specimen had not been received by the laboratory and should not have been reported. So how does that happen? A report went out that there were 3 things tested, and in fact, only 2 were tested. Right? Is that correct?
That's correct.
And that's what you're investigating?
Yes.
This ever happened before, your experience so far at OCME?
Not that I'm aware of, no.
Neither you. Has it ever happened anywhere in any lab that you've worked at?
I'm sure it has, but I'm not aware of examples.
Right. Do you care to venture a guess at this point, or some kind of help to the commission so we might consider what's going on here? I mean, the thing that scared me a little bit about reading this, and it's a little unfair to ask you these questions because the analysis is still ongoing, so it's speculation. But this is the kind of thing everybody worries about, right? This is like dry labbing almost. You know, you put in a report, you say we tested 3 things, and in fact you couldn't have tested 3 things because one of them was never even received. So I assume that you have an idea of who the tester is.
Yes.
Okay. And you're addressing that problem.
Yes.
Okay. Is a re-examination of the person, their test results in other cases already underway?
The re-examination of all laboratory testing is underway, yes.
Okay.
For all analysts, not just the individuals who were involved in this RCA.
Okay. But clearly for this particular root cause analysis, whoever that person was who said, I'm issuing a report for 3 things and only had received 2, that person, you know who it is.
Well, there's multiple people involved.
Multiple people?
Yes.
So was it a multiple mistake?
It was a miss. So
what?
A miss. So there were several people who should check the test and the sample ID, and that was wasn't missed on more than one occasion by different people.
You know, many years ago at this commission meeting, we were told about having all kinds of rules in place, and you keep doing them over and over, but still you get a little bit sloppy. And I think it was called creep, right? Was that drift? It was called Protocol Drift. Coming from our friends in Nassau County. Is that what happened here? Is it just we have the protocols in place, we're doing everything that is required as a laboratory, but somebody just got a little lazy and it went through?
So that's still under investigation. So we're looking into this in more detail, and we're doing a very thorough review.
Okay. And this root cause analysis, correct me if I'm wrong, and I think there's something in here about that. The commission will get the results of the root cause analysis.
After the meeting, a report is...
it goes to the city council, and it goes to us.
Yes, the same report.
Okay. Thank you.
Okay. Oh, actually, hold on 1 second. There's a question in Albany.
Uh-oh.
So, well, it says that 3 samples were submitted, the fluid, the liver, and the vitreous humor. It says somehow we generated results from the fluid, the vitreous humor, and the bile. Now you say there was no bile tested. Whatever happened to the liver sample?
It wasn't required for testing.
It
wasn't required for testing.
It was submitted.
Yes.
It was an accession?
It was accession, but there was no test required for liver.
Okay. So no result was reported for the liver as well. There's no possibility somebody mislabeled decomposed liver as bile and generated a report?
No, we
Okay.
understand that the mislabeling was at the original test. It was another specimen that was tested and mislabeled with the ID for the case in question. So the bile sample belonged to another case and was mislabeled with the ID for the case that we are talking about today.
So there really was a bile sample tested, it just didn't belong to this patient, right?
That's correct.
So the result that was generated was not an example of dry labbing. It's not a made-up result. It's just a result attached to the wrong case.
Yes.
Okay.
Okay.
Doctor, could I ask you a question? Was this a criminal investigation?
No.
Or was it a...
No, it's a cause of death.
No, I don't know if this is a homicide victim or it's not.
It wasn't.
Thank you.
Okay, thank you, Dr. Cooper. So the next one is the New York State Police Laboratory. It's pages 140 to 142. This is a supplemental document, not in the binder, but provided on your little desk there for you to look at. And we have Ray Wickenheiser from the State Police, if there's any questions about that. Ray?
Question. Ray, I don't know, is this an ongoing investigation?
Yes. This is something that just came to our attention 2 weeks ago, so it's very new. So we've open investigation, so it's very preliminary, but we felt just necessary to provide notification.
Without spilling the beans on any of the investigation, is a potential criminal by this person?
No, we don't believe so. This
Not
is
filing a false information?
No, I mean, this is something where certainly there was something put in a log that should not have been. As we have readings on both ends that were good, but certainly that's part of what we'll look into in terms of really, what was the intent, the mistake, and whatnot. But it's very preliminary.
Okay, other questions for? All right, thank you, Ray.
Thank you.
Next disclosure is the Suffolk County Crime Laboratory. I believe we have members of that laboratory, the QA manager and lab director in New York City, if there's any questions. Binder, pages 99 to 105, and 107 to 122, and 123 to 132.
There's 3 different.
Okay. Next lab is the Suffolk County Toxicology Laboratory, page 145 of a supplemental document. That should be outside of your binder. And I'm not sure if we know if they're in New York City or by phone. And we have members available via phone if there's any questions for Suffolk Tox.
I don't have one.
It's in one of the things.
All right, I got it.
It was, if you look at the date, this is something we received within the last day or so. So we just tried to put it in to make sure the notifications were timely.
Will this be on our agenda at your next meeting for an update on what's going on?
We can request it. The way our current policy is that they'll notify us of the opening of a corrective action and the closing of a corrective action. So if they would close it by the next one, fine. If not, it would not be for an update until they physically close it.
Okay, that's fine.
Okay. Next laboratory is the Westchester County Division of Forensic Sciences, pages 135 to 138 within your binder. And we have members of the laboratory in New York City if there's any questions.
right, if there's nothing else with regard to that disclosure, we're on to number 7 on the agenda, which thankfully is our next meeting date and location, which is June 16th. That meeting will be in New York City as the main location. Obviously, we'll have our Albany location and we'll video conference from. I do not believe we have any matters for executive session today. So with that understanding, and again, with a special thanks to all the commission members for the work that they've done on all of our issues, but particularly on the familial search issue. Do I have a motion to adjourn? All right, a second? All right, all in favor?
Aye.
All right, thank you. We'll see everyone in June.